So I want to introduce our second speaker for today, Kate Piper. Kate was a juvenile court lawyer in Vermont for 19 years and then went back to the Heller School at Brandeis to get her PhD in social policy. And she'll tell you a little bit more about why she did that in a minute. But recently, she was the chief author of the 2019 meta-survey of research related to family assessment, or differential response as it is known in most states. And that was published by the American Professional Society on Abuse of Children. As such, she literally wrote the book on family assessment, including the practices that Safe Passage and others are advocating to change in Minnesota. So Kate, we really appreciate your joining us here today. And let me start by asking you to share your experience and training in issues related to child welfare.
Thanks, Rich. For 19 years, I was the juvenile attorney in 2 counties in Vermont. I also served on a number of statewide committees to reform juvenile law. And every time I question a policy, I'd get the response, well, Kate, the research shows. And so I finally decided to go back to school and figure out what exactly the research shows. So differential response was my biggest question. And I've spent the last 9 years researching differential response. So that's how I came to be interested in this.
And by differential response, just to repeat, that's what's known as family assessment in Minnesota. So yeah. Tell us more about your research in this area, particularly as it related to family assessment in Minnesota or differential response elsewhere.
Can I first clear up some terminology? So a differential response, DR, is referring to the whole system in child protection in which the agency responds to reports of child abuse and neglect using at least 2 tracks. So higher risk cases are placed on the traditional investigation track, the TR track. The lower risk cases are placed on the assessment track, the AR track, which you in Minnesota refer to as the Family Assessment Response, FAR. So I'll use those shortcuts. It's a family assessment track, which I'll be referring to as AR, because every state has a low risk track. So I got concerned about the safety of children on the AR track. And we at the Child Policy Center of APSAC did a study and published our results last December, and you can find those at centerforchildpolicy.org. But we looked at 50 different documents, including 20 studies of DR, 20 studies of individual states using DR, and then 9 studies of involving multi-state studies. And we found that there were 8 studies that were either experimental or quasi-experimental. Should I explain that?
Probably not. It's probably not.
Okay. What we found, though, in looking at these 29 studies is there's a huge variation in the way DR is implemented from state to state and even within counties in the same state. So we found the studies supposedly supporting DR used flawed methodologies and misleading conclusions. The other finding we made is there's still no solid evidence that children whose cases are assigned to the AR track are just as safe or safer than those assigned to the TR track. And there are only 2 cases, in fact, which found that AR cases were re-reported at a lower rate than TR cases. And one of them is in Minnesota, and we feel that that study uses a flawed methodology because the equivalency created by randomization was compromised when they used survey results to identify the sample of families they looked at. So let me talk about the study that I did for my dissertation. It involved looking at the relationship between AR utilization, in other words, the percentage of cases assigned to the AR track, and the difference in re-reporting rate between the two tracks. And since the cases on the TR track are supposedly higher risk than those on the AR track, you would expect that TR cases would be re-reported at a higher rate than AR cases. And in fact, I found that was only true when less than 33% of reports were assigned to the AR track. So I think in Minnesota, you were up over 70% of cases assigned to the family assessment track. That is risky, to say the least. The other thing that our study looked at was whether the evidence supports the two underlying assumptions of the DR. The first assumption is that cases can be accurately sorted by risk level at the time the report comes in. And usually that track assignment decision is made within 24 hours of the case being reported. And it's usually based only on information the reporter is offering. So a lot of studies have found that an alarmingly high percentage of high-risk cases have been assigned to the AR track. The assumption that DR has made is that families on the AR track are going to be more likely to engage in services than families on the TR track because supposedly the AR approach is more family friendly. And study after study has proven that actually the uptake of services on the AR track is pretty low. I think there was one study done in Minnesota where only 11% of families assigned to the family assessment track received services.
Yes, that was a study which Safe Passage participated in at the Institute of Child Development at the University of Minnesota, specifically about Hennepin County. So can you tell me about states that have changed their commitment to differential response or alternative response?
Yes, thank you. There are 13 states that we found that have either ended DR, suspended it, or chosen not to extend the pilots statewide. The reasons given for these decisions to end DR were a lack of resources, inaccurate sorting of cases at the time those track decisions are made, the fact that a lot of high-risk cases are ending up on the AR track, low uptake of services for families assigned to the AR track, and then concerns about child safety. And there have been, in some states, in actually 6 states, there have been child fatalities in cases assigned to the AR track. And these are highly publicized child fatalities that often prompted the states to end DR.
All right, and then what about the trend? What do you see as the trend in this regard?
What we found is DR has evolved over time so that there's been a diffusion of best practices from each track onto the other track. So the two tracks are becoming more similar, which we think is a good thing. So the intensive fact-finding and safety assessment of the TR track has diffused onto the AR track, and the family engagement strategies and the the broader assessment of family risks, needs, and strengths has been diffused onto the TR track. And so in some states, really the only difference left between the two tracks is substantiation. Cases on the TR track are investigated. There's been fact-finding and substantiation, identification of the perpetrator, and the placement of the perpetrator's name on a central registry. But in states like Colorado and Vermont, there really is little other difference between the two tracks.
And can you just say briefly for our audience what substantiation is?
Substantiation is a formal decision that the allegations in the report are in fact true. And so that information about case substantiation is sent to the federal government, which uses it to look at maltreatment recurrence.
So you know a little bit about Minnesota and what we are working on here. What conclusions did you reach that are important for our state in particular?
One of my concerns was the whole notion of conducting child interviews with the parents present or with prior notification to the parents, giving parents the opportunity to put pressure on the child to recant or intimidate the child into silence. So one recommendation we're making is that there be no, the child is interviewed separately and there should be no prior notification to the parents until after that child has been interviewed.
On both tracks, you're saying?
On both tracks, yes. That is standard for the TR track. You interview the child before the parents are notified. And the other recommendation we made is to delay that track decision until certain things happen. There's been a review of prior child safety records. There's a review of the Department of Correction records. There's been an interview of the parent and the child. So I think it was Wyoming, the study in Wyoming resulted in a recommendation that they hold off a week before they make this track decision so that the Child Protection Agency has had a chance to speak with a child, to speak with the parents, to review the records. I think that is so important because, you know, a lot of high-risk cases are ending up on the AR track and to the detriment of children and the safety of children.
So what would you say is a change that needs to be made in terms of the number of families that end up in family assessment?
Well, I think less than 33%, less than a third of cases should be assigned to the AR track. Otherwise, you're going to have a lot of high-risk cases ending up on the AR track. I mean, that was based on my study of 12 states that had implemented DR statewide between 2002 to 2012, I think.
And then you had talked about families who come in for a second or third time. They're previously on the lower risk family assessment track and they come back in again.
Yeah, that is a real concern. Cases on the AR track that are re-reported are twice as likely to be reassigned to the AR track as TR cases that are re-reported. And, you know, that I think that if there are prior reports, accepted referrals, then those cases should not be assigned to the AR track.
And what about training caseworkers? You know, in our state, for example, we don't consistently train caseworkers in fact-finding, as I understand it, for either track, but particularly we're interested in you know, getting the idea accepted that we should do fact-finding in family assessment.
Yeah, I fully support that. I mean, how can you really make an accurate determination of risk without intensive fact-finding? without knowing whether, in fact, the allegations of abuse and neglect are true. How can you assess risk without that?
So the question is, how do your findings particularly affect children during the critical first 1,000 days of their life, which is one of the major themes of our fundraiser today?
Well, most cases reported to child protection are neglect cases, and neglect in the first 1,000 days is devastating for a child's development and can have lifelong impacts. And the fact of the matter is that, especially in cases involving young children are more likely to die of neglect than abuse. And neglect has more far-ranging consequences often than abuse. So, I saw cases of neglect that were reported over and over and over again to the Child Protection Agency. The parents made promises they would participate in services, and as soon as the Child Protection Agency went away, they dropped out, and then they'd be reported again. So that by the time I saw these cases in court, the damage to the child was just enormous. From a developmental standpoint, sometimes they were months, if not years, behind in their development. And those delays were made up very quickly once they were put in nurturing, safe homes. They made up the difference very quickly if young. Sometimes
it may not be obvious it isn't obvious, I think, to people who aren't doing this work, why neglect can be even more devastating than abuse. So I'm wondering if you can give a concrete example, maybe not a specific case, but, an incident or a situation where neglect would be devastating.
Well, the baby's brain develops by interaction with the parents, and there is, I think they call it serve and receive. With the baby asks for a response, the parents respond. If the baby is left lying in a crib with no parental interaction, with a bottle of curdled milk, a propped bottle of curdled milk, and a sodden diaper for hour after hour after hour, and there's no response to the baby crying, it's going to affect the baby's development of the brain.
Can you say a little bit more about studies that support DR or family assessment in Minnesota and why the outcomes were, in question? Can you share what was flawed about the methodologies and what was misleading about outcomes in some of the studies? Because I know in Minnesota we've relied heavily on some of those studies to promote the idea of family assessment.
The study in Minnesota that found that with families being reported for the first time, if they're assigned to the AR track, they have a lower re-reporting rate than families assigned to the TR track. And this is based on data from an experimental study where randomization created an equivalency between the two groups. In this study in particular, that equivalency was compromised because the sample was drawn only from those people responding to a survey, and there was a small response rate in that survey. So, and most studies that compare re-reporting rates find no difference between the two tracks, and in several states, they found AR re-reporting greater than TR re-reporting.
And as I think I mentioned to you at some point, in Minnesota, if you look at the annual Department of Human Services report, the number of re-reports for family assessment cases has been pretty consistently 1 or 2 percentage points higher than the traditional track. So that's consistent. in that respect. So is there anything more you could say about the evidence that children on the alternative track are just as safe or safer, and that there's not, the evidence that we think on that?
Well, I think the experimental or quasi-experimental cases that in Nebraska, Georgia, Wisconsin, and Illinois that found that re-reporting on the AR track was greater than re-reporting on the TR track raises serious concerns about the safety of children on the AR track. And also, I think the child fatalities on the AR track raise real concerns. And I've got some data on that. In Massachusetts, from 2009 to 2013, 10 children on the AR track died, including 7 in 2013 alone. In Florida, 80 children on the AR track died. And some of these children had been reported at least 10 times to the Child Protection Agency before they died. So I think those child fatality rates are pretty alarming. Those cases are alarming. In Minnesota, I think the child fatality case of Eric Dean raised a lot of concerns among child advocates.
Yes, and I think that reporter also looked at more than 50 other children similarly known to child protection. Many of them were as well on the family assessment track. We don't have ongoing data. We can't look at that regularly without doing some special study, but that was, I think, an eye-opener for people here. Yeah. And so do you have any opinion about why the uptake of services for the alternative track is not as high as was expected?
Yeah, I think the uptake of services on the AR track is high when it comes to receiving material benefits, like, something, help with food, housing, transportation. But when it comes to the uptake of services to address the chronic underlying conditions, such as substance abuse, mental illness, domestic violence, the uptake of services is low. And it could be because the agency is not pushing it and not involved with helping families overcome the challenges to engage in these services, or it's just denial. We know that denial is a huge part of substance abuse, and if people don't think they have a problem, they're not going to engage in services. And so, you see the services that are more likely on the TR track are those involving substance abuse and mental illness and domestic violence, because there is a level of coercion because of the agency's continued involvement with the family.
You may know that one of the reforms that got through as a result of the governor's Child Protection Task Force was to say that no child protection response is voluntary. And that was specifically aimed at voluntary family assessment cases where the family just closed the case of their own volition. And secondly, that if a family hasn't been working its case plan, following the things they agreed to, that counties can't close the case without first consulting with the county attorney. So there's a couple of checks and balances that have been put in place here that hopefully will address some of what your concerns are.
That's great news. That's wonderful. Because if families think it's voluntary, I think over 50% of families just close the case themselves. They just decline services and the case is closed. So right. That's concerning, especially if we're dealing with a high-risk family.
Right, and the study that we were participating in with the Institute of Child Development, 62% of the cases in that particular county were closed at the request of the parents. And so a situation where a family is reported numerous times before they're even screened in, and then they're assigned to the alternative track and they close of their own volition, that churning process starts all over again.
Our recommendation is that the track assignment does not take place until certain things happen. So delay track assignment until the child is interviewed separately prior to notification by the parents, and the parents are interviewed, and there is a thorough review of records, child protection records, court records, Department of Correction records. And I think, this could be done within a week. So, our recommendation is to at least delay track assignment until all this happens. And some advocates believe that track assignment should not occur until there's been a thorough risk assessment conducted. And then, you have a better idea of the correct response.